if you are here for 2322, 1948, 1951, 2321, or 2127, patrons have asked that those bills not be heard today. So if you're here for just those bills, you can leave. Those bills are not going to be heard. Otherwise, we're going to wait for one more person to show up.
I didn't want to miss you.
Stick to things that are directly.
We're going to go ahead and come to order. We have a large number of bills. Let's go and do the bills that are going by. So the following bills have been asked by the patron to go by, and per our practice, they will go to the end of the queue. It either means our last day, or if we can get through everything before, then it'll be before the last day. But they are House Bill 2322, Delegate Aird, House Bill 1948, and House Bill 1951, Delegate Peace, House Bill 2321, Delegate Moorfield, House Bill 2127, Delegate Levine. The patrons have all asked that they go by, so I won't ask for such a motion. Somebody? Okay. All in favor signify by saying aye. Aye. Opposed? Okay. Is there anybody who is, the sign-up sheet does not exactly match who is out there? Same. So, all right, Delegate Pillion, you're first. 2166.
Thank you, Mr. Chairman. So as many of you know, I've spent the past year working on coming up with legislation that addresses the opioid crisis that's affecting Southwest Virginia, the Commonwealth, and our country as a whole. And while this approach has mostly been focused on the healthcare aspect, there are some things that I think that we could do through the judicial system as well. So I've tried to introduce legislation that would be helpful in combating this problem from every angle. So 2166 is legislation that's a product of a collaboration between myself and 8 Commonwealth attorneys that met with me from Southwestern Virginia, as well as several judges. We had a fall meeting to discuss all the aspects of the opioid epidemic and how it affects their courtrooms, including better tracking and reporting for frequently abused substances. So what this bill does, currently the Virginia Code Schedules 1 and 2 substances are linked together. So possessions of Oxycontin, meth, and heroin are all under the same code. With each of these, with this bill, each of these would have its own individual. So we've taken the top 10 of the Schedule 1 and 2s, and we've divided them out, the ones that they most commonly see in their courtrooms. And then under and then group the rest of the Schedule 1s and 2s that they don't see as frequently, kept them under one section. And then under the Schedule 3, we removed buprenorphine and created another line for that because they're seen and frequently used in their courtrooms throughout Southwest Virginia. So this would better allow us to track what's being abused in Richmond, what's being abused in Southwest Virginia, so we can see where the trends are and how we can effectively treat it.
And this doesn't affect any of the penalties, it just says how we record them as they come in so we know what actually the drug is rather than a category.
Yes, Mr. Chairman.
Okay. Anybody have any questions for the patron? Anybody in the public like to be heard on this? Staff have any issues? Okay. What's our pleasure on the bill? Motion has been made to report. Is there a second? Okay. All in favor signify by saying aye. 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 Opposed? Okay. Delegate Queen. Thank you.
Thank you.
I have Delegate Carr, 1931.
Thank you, Mr. Chairman, members of the committee. House Bill 1931 would allow for a local option to create a new class of employee known as a Fair Enforcement Inspector. The option for Planning District 8 passed in 2014, and this bill simply adds District 15. The transit system will be the employer of the inspectors. These inspectors would have the authority to issue civil citations for failure to provide proof of payment on transit systems, and the civil penalty for failure to provide such a payment is not more than $100. New technology that will be used with the new Bus Rapid Transit BRT vehicles in Richmond will allow for off-board fare payment, meaning that the rider will pay before boarding the bus. This will allow for speedier bus service and clearing of travel lanes. The Bus Rapid Transit system in Richmond is scheduled to open by the end of October 2017. These inspectors will free up sworn police for higher safety and security issues while ensuring the proper payment of the fare to use the system. I know at least one person, Mr. David Green, who is the Chief Executive Officer of the Greater Richmond Transit Company, GRTC, is here to speak in support of the bill.
Okay, I think I started reading when you started talking, so I wasn't listening closely enough. I apologize.
That's right.
The problem is what? What's the problem we're trying to fix?
The problem is that with the new system of the Bus Rapid Transit, there wouldn't be any way to collect the fare unless there is a fare enforcer on the Rapid Transit. It's a different system. It's not you get up and you put your change in the little box, little case on the.
So those of us mice who come from the country.
That's right.
Not is there a card? How does it work? How do
Yeah. So like in some. My experience with it is like in European countries and stuff, you get a ticket at a little booth and then you get on and you give that to get off. I'll let Mr. Green, if I may, talk about it.
Okay. Yes, sir. So we're trying to determine what's the problem and how does this fix it?
Yes, sir. Good afternoon, Mr. Chairman. I'm David Green, CEO of GRTC Transit System, and we are the transit operator in the local Richmond region. So we're implementing a BRT system. It's going to extend from Willawon in Henrico County to Rockets Landing in the city of Richmond. Fixed guideway systems such as BRT or light rail offer many features that allow the service to operate much more quickly than traditional bus service. If you board a typical fixed route bus, you're going to climb the stairs, you're going to approach a fare box, you're going to pay your fare at the fare box before taking your seat, and there's a bus operator that ensures that people who actually board that vehicle pay before they do take their seat. BRT buses have no fare box, so customers will pay for their ride before the bus ever gets to the station, and they will do that via a ticket vending machine. It's called off-board fare technology. So, and it's similar to a subway. So people who are waiting for the vehicle will purchase their fare on a platform, and they'll validate the fare on the ticket vending machine prior to that vehicle ever arriving. So once the vehicle shows up, it stops, doors open, people get on board, doors close, and the vehicle takes off. It's much, much quicker. So what this bill will allow us to do is to employ fare enforcement inspectors who actually ride vehicles and ask customers to prove that they, in fact, paid for their ride. Fare revenue is extremely important to transit operators in order to support the service that we provide. Ensuring that people pay for the service that they actually use is important to us. One of the other benefits of this bill is that it covers the entire planning district within the Richmond region. Again, this service will operate in both Henrico County and the city of Richmond, so it will prevent us from having to have separate policies to enforce fare collection. It'll also set us up in the event that service for BRT is expanded into other jurisdictions besides Richmond and Henrico County.
Okay, is there if I walk through in Metro, which I do know, you can't get into the place without putting a card in. Maybe you don't go where you're supposed to go or something, but at least in terms of going through the turnstile?
Correct.
Okay.
So these particular BRT stations would be uncontrolled. They will not have turnstiles. So it's kind of based on an honor system.
Okay.
Many BRT systems operate.
I come in from Charlottesville. I've never heard of such a thing. I get on the bus. I understand that we should have some kind of check so they make sure I pay. That makes sense to me, but this is more than that. This is a $100 civil penalty. How do I know that that's what what informs me that I'm subject to a civil penalty if I get on the bus without?
Signage, educational campaign. We will inform the public once we roll the service out as part of that educational campaign, various procedures and policies that relate to the BRT service.
Mr. Chairman, if I could ask a question.
Collins, can I ask one more? Sure.
Of course you can.
What the percentage? Okay, so this has been working in some other place because we're adding a planning district. Somewhere else is already in place, right?
Yes.
Okay. How much of their income comes from the penalties versus just people paying the fares? Do you have?
I don't know. I do know that fare evasion is a problem in the transit industry across the nation. So it's something that transit companies take very seriously and try to deter.
Okay. Yes, sir. Delegate Collins.
So I assume that you already have this in Planning District 8. Is that correct?
It exists up in Northern Virginia, yes, sir.
Okay. So Planning District 15 is Richmond. Okay. So is it successful in Planning District 8? Have we had any issues up in Planning?
They have.
That's your bailiwick? I'm sorry.
That's all right. I'm Lisa Guthrie with the Virginia Transit Association. In 2014, this bill was adopted to apply to Planning District 8. From my understanding from some of the operators up there, including Metro, they have not had to implement it yet, but they expect that they will very soon.
Thank you.
Thank you.
Mr. Chairman.
Ms. Watts. Delegate.
Just bringing a couple of other facts on the table representing that area. It went through in about 2014. It went through basically on about a 70 to 25 vote in the House. Out of some concerns that are being expressed, I've never heard a problem from any constituent, and it was carried in the House by former Delegate Rust, who spoke at the time, as I recall, about why you needed that $100 is that you had some frequent flyers who did it again and again and again. So this was there as a backup for those who were really trying to game the system, but that it would not be what is normally used, which we've just heard, in fact, it hasn't been used. And again, just to clarify, our system is buses, rail cars, as well as Metro Rail. So they all have 3 different collection systems.
All right, anybody else have any questions for the patron or the speakers? Would any other member of the public like to be heard? Staff have any issues?
Delegate Belton, Mr. Chairman, just to answer your question, the $100 penalty is actually a penalty for riding a train without a fare, so it's not distinct to this section. It comes from ATJ 1.1, and it's actually payable to the Commonwealth, not the
Okay.
transit system.
Okay. What is our pleasure in building?
Move for recall.
Motion's been made and seconded to report the bill. All in favor signify by saying aye. Aye. Opposed? Okay. At least one no. Morris is no. Okay. There's been some interest in your bill. We're short some members. If you want to, you're welcome to stay, but I'm going to pass you by temporarily. And if you want to go and come back, that's fine too. Delegate Moorfield, we moved one of your bills already per your request.
Yes,
And
Mr.
then
Chairman.
that left the other one. So what bill do you want to take up?
Mr. Chairman, members of the committee, we have House Bill 2329. This was brought to me on behalf of the Capitol Police.
Tell us the problem and tell us how this fixes it.
Okay, it's a technical correction, section 19.2-81, and what the bill would do is add the Division of Capitol Police to the list of agencies who may have warrant for any person who commits a crime in the presence of an officer, or any person whom he has reasonable grounds, probable cause to suspect of having committed a felony without obtaining a warrant to do so.
So this would add them to the fairly lengthy list of sheriffs, state police, Coast Guard, conservation officers.
Yes, Mr. Chairman.
Are you aware of any reason why they were not there originally?
According to them, and I'm thinking, speak if you like, but I think that it was just an oversight.
Okay. Yes, sir. Tell us your name and your thoughts on the bill.
Mr. Chairman, Steve Whitmer on behalf of the Capitol Police. I went back as far as the electronic records of legislative history go back, which is 1995, and we appear to have been omitted from the original version of this bill. I don't have any idea why, but we'd like to be in it.
Okay. Any other member of the public like to be heard? Staff have any issues with this measure? What is our pleasure? Motion is made for report. Is there a second? All in favor signify by saying aye. Aye. Opposed? Thank you, Delegate Moorfield.
Thank you, Mr.
All
Chairman.
right. Delegate Heretic.
Thank you, Mr. Chairman. Good afternoon. This is House Bill 1903, which would seek to extend the same admissibility to business records in criminal cases that we currently see in civil cases, amending 801-390.3 and Virginia Rule of Evidence 2:902 sub 6. Mr. Chairman, very simply, I think this bill passed out of the House a number of years ago, which would amend it out to both civil and criminal proceedings. It came back from the Senate for reasons that are unclear to me, with only allowing this in civil proceedings at the request of some friends in several Commonwealth Attorney's offices, and I understand there may be some representatives of VACA here this afternoon in support. This would simply reinstate the applicability of this rule to criminal and civil proceedings.
And so for the non-lawyers, this would eliminate the need for authentication by walk through the difference.
Basically, Mr. Chairman, is this. Currently in civil cases, if I plan to introduce a business record, which is normally subject to a hearsay exception, I could offer that record to opposing counsel within more than 15 days before a hearing or a trial, with the necessary affidavits of certification of authenticity. Then defense counsel or opposing counsel could object to it if they find problems with it, at which point I would have to bring a live witness, a custodian of records, to introduce those documents. This simply extends the same rule to criminal proceedings as well.
Okay. Do you remember the bill?
I don't recall that several years ago. I don't remember the number.
Also, it came out of the Boyd Graves Conference where
Okay.
the source of the bill.
Can you look at the vote as a courtesy to the members that voted last time? Just make sure that people know how they voted before.
Mr. Chairman, it was unanimous on both sides.
Okay. All right. So, anybody have any questions for Delegate Heretic? I assume that if it came out of Boyd Graves and we went through this once before, that there's not any ongoing constitutional issues that have popped up or confrontation clause or anything like that?
Mr. Chairman, no, I think the main reason is because Boyd Graves is the civil side of the Virginia Bar Association, that it was determined during the process that they were only going to focus on what their expertise was in.
Okay, well, let me ask you then, is there any issue that we need to worry about that somehow you were foreclosing a constitutional confrontation or anything like that?
Mr. Chairman, I've looked into the constitutionality of it. There's two reasons it's constitutional. Business records aren't normally testimonial, so they don't apply. Confrontation wouldn't apply. Also, it's got the notice and demand language that's necessary to take care of that, so no problems there.
Okay. Any member of the public like to be heard? Commonwealth's, I assume, we voted for this before, so I don't think it's controversial. Are you okay with this?
I probably didn't either.
Probably don't.
Joel Branscombe, Commissary, about that kind of half back, and we do support the bill. I think work with some commissary to get this done.
Any other member of the public like to be heard? What is our pleasure on the bill? Okay. Motion made and seconded to report the bill. All in favor signify by saying aye. Aye. Opposed. Okay. Delegate, we're holding Jim Heifer. Okay, so there's Mark, excuse me, we have an identical bill, and while I could predict what will happen, we shouldn't do that until he's here. Delegate Torian is here with an identical bill. Okay, can you just give us 5 minutes to see if we can get him here before we...
I saw Luke in the back of the chambers, and I'm being told, we were both carrying this bill for Prince William County. Prince William County's here to present. Luke, I think Luke is aware that that's going to happen.
And he's come, I'm not as quick on the spot, but what's about to happen is we will table his, allow him to co-patron yours. I don't like doing that if he's not here. Is that your understanding, what his understanding is?
Mr. Chairman, Jim Council representing Prince William. Delegate Torian is in appropriations. I just spoke with his aide, and his aide is expecting us to present the bill.
That's fine. Good. Okay. All right. So we have two bills, 2195 and 1828, identical bills. All right. So, Mr. Dudenham, let's just work from yours. What is the problem, and how does your bill fix it?
I'm going to defer to the expert.
You bet. So identify yourself.
Mr. Chairman, Jim Council, I represent Prince William Schools, and pleasure to be before courts of justice today. This is a very technical bill, although I don't think it's very complex. And to give you a little background on it, Virginia Code Section 22.1262 actually provides that when a student's absenteeism persists, that the attendance officer, after going through some administrative procedures, is then supposed to make complaint about the pupil's parent in the name of the Commonwealth before the Juvenile and Domestic Relations Court. Now, recently, some judges in Northern Virginia J&D courts have apparently raised the question of whether the signing of the documents and appearance on behalf of the school by the attendance officers constitutes an unauthorized practice of law. And that's what a bill today tries to clarify. I don't think we've heard that complaint from anywhere else in the Commonwealth. It's my understanding that there's a lot of frustration in the Northern Virginia courts right now because there are just so many of these truancy cases before them, and it's consuming a lot of their time. But I will tell you this, a similar situation arose with connection with social workers some years ago, and there was an Attorney General's opinion issued, and it read, it shall be the duty, and it read that prior opinions consistently conclude that non-lawyer employees of state agencies may appear in court, obtain warrants, and present facts, figures, and factual conclusions. And so we have an AG opinion that I think supports what we're trying to clarify today. And I see a couple on your panel that may have better insight to this than I do. But the fallback position under the statute would be that these cases are prosecuted by the Commonwealth's attorney's offices. And it's my understanding that they just don't have the time and don't want to pursue the effort to take on this burden. So what we're asking today in the bill is that we just clarify, as previously done for social workers appearing in J&D court, that in a very specified procedure provided by statute, that attendance officers signing these petitions on truancy and appearing in court does not constitute an unauthorized practice of law.
So, it's been 20 years since I've done a truancy case, so it doesn't sound like our procedure is anything like what you're describing anyway. So, back in the day, we would have someone identify students who were truant, and then someone, and I guess I don't know who did that, someone would file the equivalent of a complaint. They would that would create a petition. The petition would be served on the student, and then the student, like anybody else in juvenile court, would have to come with his parents. But at that point, I was the Commonwealth, and I would then take the case as the Commonwealth. Correct. Sounds like that's not the process that most places use, or is no longer practical.
Well, just to back up a little bit, the attendance officer is either the superintendent or his designee under the statute. And of course, in the larger school divisions, it's typically going to be a designee. Okay. There's certain administrative steps that the attendance officer is supposed to step through prior to filing a petition. You're supposed to work to get the parents in, try and remediate the problem administratively. Only after those fail does the statute kick in that not only authorizes but actually directs the attendance officer to initiate the petition and appear in court.
And that's current law?
That's correct.
Okay, so and what's the problem when they get to court? They're not allowed to speak, or?
I don't think the judges have denied them the right to go on and prosecute existing cases, but I know there have been a lot of meetings up there among the judges and among school representatives about a concern that this is an unauthorized practice of law. I would say also, I actually on January the 2nd sent a lengthy letter to the Jim McCauley at the State Bar, but I haven't gotten any response from him.
I guess I'm not asking the question very well. What are the things they are doing that might be seen as unauthorized practice? What is it's not filing the petition?
Mr. Chairman, it is.
Yeah.
It is filing the petition. It's just like when we have the DSS with the CPS case, that some judges are determining that to be a legal document, and therefore it is a legal document requesting a petition to be issued for the child, so therefore that is the practice of law, even though they are checking boxes and filling in the last name, middle name, first name on those forms.
Okay, and
Mr. Chairman?
Just wanted to make sure I'm just trying to get information, what do the judges think should be happening? Should be the council attorneys doing it, or a lawyer for the schools, or
in our jurisdiction, they allow the school resource officers they actually have the school resource officer, a police officer, filling out, in essence, a request for a warrant. And then our juvenile intake, then issues the petition. But the judge signs off on that petition. Okay. So it's like it's a magisterial type system.
Okay.
Mr. Chairman, just to clarify, in most jurisdictions, Commonwealth's attorneys do not prosecute CHINS cases because of the sheer volume of them. They're not ascribed specifically to the Commonwealth's attorneys within the code, like felonies are. In instances like this, it's common practice in many jurisdictions I've been in before that the Department of Social Services employee is the person who actually gets the CHINS petition and then prosecutes the CHINS petition before the court. And that AG opinion has allowed for that. I have not been aware of before instances where that was done by a school attendance officer, but that appears to be the instance that is occurring in Prince William because of the sheer volume of CHINS petitions that result from poor attendance.
Okay. All right. I was asking questions. Any other member of the panel have any questions for the patron? Any other member of the public like to be heard? Let's talk among our, yes sir, Mr. Cotter.
Mr. Chairman, I just have one technical point, which is I believe we probably need to add on line 93 after 22.2-258, 22.1-262, because the attendance officer is able to file a complaint under either of those two sections.
Correct.
So it's just missing one code section covering all that the attendance officer can do.
There's two. This is, the Torian bill will be, we're not allowed to roll right now, but it will be tabled and then keep as the patron as it proceeds.
Mr. Chairman.
Delegate Klein.
I'm sorry, I had to step out from them. Was it discussed, I left just as you were bringing up the question of the unauthorized practice of law. We had, I mean, this has been an issue for those of us in the Shenandoah Valley when it comes to child custody and child support, actually child support complaints for some time. We went to court. Courts actually ruled that there was unauthorized practice of law occurring. We had to come in and change the statute to actually ensure that attorneys were the ones, or actually they passed statute allowing for exactly this, the unauthorized practice of law. And I did not support that bill, so I do have some concerns about this. When non-attorneys are filing court papers, documents, so I'm not going to support the bill.
Mr. Chairman, if I may.
Just a second. No. Any other delegate have anything they'd like to say? I'll certainly give you a chance to respond. Yes, sir.
No, I was just going to add, Mr. Chairman, that it's my understanding that what they're actually doing is perfectly consistent with the Attorney General's opinion, in that they are filling out forms, presenting facts to the court, and then the court, of course, makes the, or reaches the legal conclusion on the disposition of the case.
Yes, sir. Counsel.
Mr. Chairman, I think the committee needs to be aware of the difference between these sort of cases and those cases in which the Department of Social Services are filling out petitions. Those are the type of cases like abuse and neglect petitions, parental permanency planning reviews, foster care reviews, where there really are just filling out paperwork. In these cases, if you look at 16.1.260, which is the intake and petition statute, truancy officers have to appear through that statute in front of an intake officer because there is a procedure for diversion. And so if we allow this bill to move forward as it is, the attendance officer can then skip the diversion procedure and bring children directly to court, where they wouldn't ultimately do that because the code has laid out that there is a procedure where the intake officer is actually to make sure that the school has done what they're required to do prior to filing that petition. So I think that needs to be this is different than the social services complaints where there really is a procedural, ministerial filling out paperwork.
Do you have any thoughts on that?
No, I don't, Mr. Chairman. I mean, I still, it's my understanding that what he's doing is filling out forms and presenting the facts, basically the attendance record of the child, and I'm sure relating to the court what he has gone through previously from an administrative standpoint, obviously without success to bring them to that point where the petition is filed in J&D court.
Yes, we represent the whole state. Usually when something like this happens, we have an initial question of we should be hearing it from everybody, or it's what we call a judge problem, which would be there's a problem in some area or even just a single judge who is out of 19 judges is the one who somehow has magically come up with a different answer. Do you know if this is happening? I mean, is this happening in Albemarle County, Danville, and Richmond? And
Mr. Chairman, I'm only aware of it in Northern Virginia, primarily Prince William and Manassas.
Delegate Klein.
I'm sympathetic to the problems going on in Northern Virginia. Obviously, a population issue going on, but I'm going to move the table.
Okay. Gentleman from Rockbridge has moved to table the bill. Is there a second? Sorry, is there a second? Okay. Motion has been made and seconded to table the bill. All in favor of tabling the bill signify by saying aye. Aye. Opposed? Okay. Didn't have to share the ayes have it. Thank you. Thank you, Mr.
Thank you, Mr. Chairman.
I will. Yeah. Okay. All right. Let's take up the House Bill 2195, which is identical. Delegate Klein, you want to make the same motion? Motion has been made, and does Delegate Morris second again? Okay. 2195, which is an identical bill. All in favor signify by saying aye. This is the table. Aye. Opposed. Okay, thank you. Delegate Weaver, you're up. I choose not to follow that. That's fine. You can choose whatever you want. Delegate, go ahead. Tell us the problem. Tell us what your bill does to fix it. Nice to have you here.
Essentially, the issue is that there are some folks who feel that cursing in public should not be a crime. That the bill removes an unnecessary restriction on the exercise of free speech. It stems, as I presented last year, stems essentially from a Virginia Beach ordinance that was overturned. And just quite frankly, if I'm walking down the street and I happen to stub my toe and curse, and my officer currently has the ability to slap me.
Who brought you this read?
We brought it last year. I honestly can't remember.
Delegate Klein.
Huh?
I can't. Council,
Do you remember
what happened last year?
Table by the same table.
Mr. Chairman, a bill was tabled in the subcommittee last year.
All right. Any member of the public have any questions? Hopefully not profane for Delegate. No. Any member of the public like to be heard on this matter?
I know you will.
Delegate Miller, I believe last time you were the one that made the speech, but would you like to make it again?
I don't think that's
Did it include profanity?
No.
It did not.
We operate by motion. Is there a motion on the bill? The motion is made to report the bill. Is there a second? Motion fails for a second. Thank you, Delegate. Appreciate your time. Okay, Delegate Ransom, you are here again. Do you have some new language for us?
Yes, sir. I do, Mr. Chairman. I have an amendment and a major substitute for the committee today. And I'm hoping that I've captured the language that I needed to capture. Is it past the hour?
Margaret, let's go ahead. He's literally getting the draft.
Oh,
This is one
okay.
we're going to look at the exact words, so
Right.
let's go ahead and pass by for just a second. We have David Bulliva here. Has Bulliva come? See him? Yost here. Don't see him. All right, Les, are you? And let's use the time productively. All the way down in block 3, you've got 2268. You want to just take that while we're waiting?
Yes.
It looks simple.
Yes.
All right, everybody, we have a DUI day, but this looked like it's single and not really has to be part of our big DUI day, so 2268.
Okay, Mr. Chairman, this bill amends the statute relating to violations of the ignition interlock procedures and basically establishes the venue to make it clear that it can be
in multiple jurisdictions, depending on what's most convenient or the choices made by the prosecution. Specifically, it sets the venue as where the offense was committed, where the defendant resides, or where the initial order prohibiting the person from operating the motor vehicle that is not equipped with a functioning ignition interlock system was entered.
So give us an example with real counties. I get convicted of DUI in Altamar, I drive to Madison, and I'm trying to think how the order would be. Could you just walk us through how this works?
So if there is let's say the order is entered in one county, but the system is installed in another, or someone lives in another county, and one of the violations occurs where, say, someone tampers with the system, or another person furnishes, the person will be prosecuted in that case, the person furnishes the offender a vehicle that was not equipped, but if that person does that in a different county, could be any county, it would make sense that the prosecution happened there where it's probably found out and investigated and prosecuted. So the venue here would allow for that scenario.
Do we have any other code sections with sort of multiple choices for venue? I know we've got a few, I think.
Mr. Chairman, there are several other code sections. They are typically the crimes that are hard to define, the area in which they occur. The computer trespass is one of them. The purpose, I think, in these cases, when you take to find tampering, it would have to be when they do the download each month of the ignition interlock. In those cases, and obviously, if you had to do that every time you had to go to the trigger, you would never be able to tell where the actual tamper occurred. And so, I think that's the purpose. But there are several code sections in which, and it includes where the defendant resides, where the offense is committed, and there are several. I can pull them up.
Take a look at them. So, is the idea? I'm trying to think of why resides, but that's. Let me posit this: somebody, Virginia Beach guy, visits Albemarle County for one of the big parties, has the offense in Albemarle County. Then, of course, he goes back. He's being monitored out of Virginia Beach because that's where he lives, that's where he works, that's where he. Okay. So what you're saying would be when there's a violation, it doesn't make sense to bring it back to Albemarle County.
Correct.
Okay, so I get that one. Yeah, no, that's what I was going to ask. But it happens in. I guess the question is where it's happening. Is that the issue?
Well,
I'm having trouble being abstract.
That could be one issue. Another could be, I suppose, if he resides in one area, it could be found out somewhere else. The statute is drafted would allow it to be in the area where he resides as well.
Mr. Chairman.
Delegate Gilbert.
But so
Who's you?
Well, one would want to prosecute this person in the place where they were caught violating the statute, and one might want to prosecute them in the place where the judge told them not to. But why would you ever want to do it in the place where they reside if that represents a third place? Like, who cares? Who in that place cares about that?
We have a representative from ASAP.
Yes, sir. Yeah, please.
Mr. Chairman, Richard Foy from Commission on ASAP. That particular scenario would be for people who have what we refer to as an administrative ignition interlock requirement. This is a requirement from DMV, and in that case, residents can petition the court in which the area in which they reside in order to get the restricted permit. So these are usually cases that are years old, they're going to become back, that type of thing. The main issue on all of this, though, is that we can't establish where the offense occurs. And since we have had to have cameras installed.
I'm not smart enough. What's the offense? What are we talking about? I mean, he breathes in dirty and you don't find out until later?
We have new ignition interlock regulations that went in July of last year, and one of the requirements of those regulations have cameras installed, and we are seeing a rash of violations of various types on the photographs. The most common one is having people other than the offender blow for them. Oftentimes it's the people's children.
And so they don't know where the breathing took place. They just know the camera comes in and they can see Elbo's big head leaning over. Okay. All right. Any other member of the public like to be heard on this measure?
necessarily where the information occurs, but that the violation occurred, and this would eliminate the venue problem.
Delegate Alba.
Delegate Adams. Isn't the problem just with the tampering and not with the blowing positive? The problem with proving venue is with camp? Or is it with everything?
I suppose it could be with everything. Yeah, there's several, I think the judge, many times the court that issued the order would be the one you'd like to have in front of it, if you could. But it certainly could fall back to where it resides. And it seems like you want to bring it back to the court where they said, don't do this. And we put the ignition interlock on. So that seems to make a lot more sense than having some of the court that doesn't know that the purpose of that is necessary.
Yes, question.
Delegate Alba.
Delegate Adams, I mean, is somebody gets charged with blowing positive on an interlock, and the defense attorney says you can't prove jurisdiction because you can't prove that the person blew within the jurisdiction of this court, right? Is that what it is?
Well, venue technically.
Venue.
Yes. Yeah. Right, that's part of it. I mean, the language immediately preceding the amended section lays out those different scenarios or different prohibitions, all relating to ignition interlock. Some of them, the improper use, some of the tampering.
I'm surprised I haven't heard it before.
Now it's gone. You got 3 months. Delegate Miller.
Mr. Chairman, to explain it to Chairman Aldo and Chairman Aldo in a good, I won't do it as well as him, but in a common man's wording. You have a guy that's been convicted in Fairfax, and everything's being done in Fairfax. He's going to ASAP in Fairfax and everything. Then he goes down to UVA or wherever, somewhere in the middle of the state, gets drunk as all get out, gets in his car, tries to start it. The picture shows a picture of him failing, but he's in Central Virginia. He's not in Fairfax. They go to charge him. He says, well, you can't, who says I was in Fairfax? You can't charge me there. I wasn't in Fairfax. Okay, well, we got to charge you for your violation, so we're going to charge you in this venue, regardless of where you were blowing in your ignition.
Counsel.
Mr. Chairman, I think this bill does not criminalize the positive result. This bill criminalizes somebody else blowing for you, somebody giving you a vehicle that doesn't have an interlock, and tampering with the system. So positive result typically is taken care of as a probation violation. And I think the issue with the venue in this case is that the ASAP people are not going to know the violation occurred until they do their download. And so they'll have no idea where in that 30-day period on this day when somebody else leans over and blows into the machine where you were when that occurred. That's why they're asking for it.
Okay. All right. Got a motion on the bill.
Move to report.
For a second. All in favor signify by saying aye.
Aye.
Opposed. Mr. Secretary, former member of the panel, welcome. Are you here on a particular bill?
I'm not.
Glad to have you here.
I'm just here observing and learning.
Missing the fun.
Not necessarily.
All right, Delegate Ransom, I hope you have.
Wondering why you didn't run again.
So everybody, this was the bill about requiring the Supreme Court to make its records open, if you remember. On deck.
Mr. Chairman, I have an amendment before you on House Bill 1844. And when we left on Monday, there were concerns from the Executive Secretary's office and from Action Alliance, and I addressed those on line 19. So I put in the word participating circuit courts, and then participating localities, participating courts. So just adding that language in. And then for Action Alliance, we added in the words on line 21. The information available on such system, comma, shall not contain the name of the alleged victim.
Okay, so everybody, we had a lengthy discussion about this bill last time. Members of the public, this is a bill that came up before, and Delegate Benson has gone back and come up with a different draft. However, if you did not testify, or if you see something on this that is different than what you testified to before, be happy to hear the testimony. So any member of the public like to be heard on this measure? Any member of the panel have any questions for Delegate Ranson?
I have a question for the Supreme Court.
Madam Supreme Court.
Good afternoon, Mr. Chairman. Christy Wright, Office of the Executive Secretary. We have reviewed this language and we're fine with it. The one concern that we do have is we'd asked if there could be a delayed enactment clause to provide time to make the changes and implement it. Very difficult to do it by July 1 of 2017. We had asked for a 1-year delay for July 1 of 2018.
Mr. Chair.
Yes, Delegate. Go.
That seems valid enough, I guess. I just want to ask, the language that was meant to ease the collective minds of the Action Alliance, that's not really necessary, is it? Is there anywhere in any of the Supreme Court system that contains the name of the victim?
Not that I'm not available on the public site, not that I'm aware of.
Mr. Chairman, there is, if the complaining witness is a complainant on a magistrate-issued citizen complaint, it will appear.
That's true on that, yeah.
Well, shouldn't we say no? Because most of it's 99% of the time it's 99, but yeah.
This is a
The difficulty with that is that is something, so that's a field that's made viewable. And so it's, you either show the field or you don't show the field.
Right.
And so to go in and decide, is it an officer, is it an individual who made the complaint?
No, what we're saying would be very easy to hide it for all. One of the most commonly used features of this is the name of the officer. And every practitioner, every clerk's office is saved hundreds of calls by being able to just say, I see it's Officer Smith,
yes.
Whether it is court dates or something.
So what if Officer Smith is the victim? I mean, I know we're trying to make somebody happy here, but I think it's to solve a problem that really doesn't exist in large part. So,
Jane,
I understand trying to placate people, but not at the expense of messing this up. So I don't think it's.
What if we did that just for what if we treated domestic court differently? I mean, it is different. I mean, it's going to have to be that for domestic cases, we don't list the complaint.
I mean, it's currently not available now.
Right.
So they don't have the benefit of that right now.
Right, you don't even have any of it up right now, so you could, if you were starting from scratch, I guess. Yeah.
Okay. So let me speak it out in whatever the normal language is. So, Mr. Cotter, if we said, do we use the word victim or complainant? I thought it was complainant.
Let's do different things, or maybe it's the same thing.
Well, nothing has the victims there.
You're
Only
concerned about the victim.
Well, I understand, and what she's reminding us is that sometimes you will see that the victim's name, because the victim is the complainant on a non-officer brought warrant, and so it shows up as the complainant. We don't have to worry about the victim's name, we need to worry about the complainant. If we're trying to not have it show, we need to worry about the complainant's name. Our problem is, so, there's no place that shows the victim, it shows the person that brought the warrant. Usually it's a cop, but sometimes it's Margaret Ranson, and then Ranson will appear on the issue. And the problem is, one of the reasons we use this is the name of the complainant helps us continue. This is mostly for scheduling and continuing cases. That's the primary use, and that's what we all use it for. If we scrub that off, it becomes almost unusable. The point of it is to say, oh, it's Officer Jones. Officer Jones has it every third Tuesday. It's his court date. We need to be able to use it. Ms. Hall, I mean, we're trying to get what you're getting at, but it's going to be very hard. The only way I can think of it, there'll be some district court complainants who will show up. They're already showing up. It doesn't make it worse. It just makes it easier to find them. If you already are looking for them right county, you can already do it.
You're on the general. It would be on the general district.
Domestic, it happens all the time.
Mr. Chairman,
Counsel.
If it is a magistrate-issued complainant warrant, it's not as if the name of the complainant is hidden anywhere else. If somebody were to go down to the courthouse. In some, when it's an officer, they use initials to hide the victim's name, that sort of thing. But when you go to the magistrate, I think you open yourself up to signing these court documents that are public record.
That's the court.
Even if you take out a criminal warrant against somebody, you got to sign the warrant. You got to sign the criminal complaint.
The internet's different.
But can
So
his buddy?
the internet is different. I just wanted to point out that it is public record already.
Our Jane Court will not release the records to anybody. They're not.
I know some won't release. I know they won't release juvenile courts, but everyone I've been has tried it. If you want an adult file, you can look at it.
You're not my 16th. That's good. Makes it a real pain in the neck. All right. So, Margaret. So I mean, here are our choices. I think Delegate Ransom. So our choices are do nothing, just we can't find a way to make all these pieces work. Release everything, which would mean that at least on occasion the complainant's name would show up, or at least we're discussing the possibility of saying for domestic cases the complainant does not appear, but for the rest it does. Now I don't know if that's got a consensus up here or not.
I mean, I think if you're going to do that third option, the ideal way to do it would be any non-police officer complainant doesn't show up. I just don't know that they can make that work.
There's no designation that identifies whether it's a police officer or not. It would make it less useful for practitioners, but right now practitioners don't have this anyway, so it's not like it's a huge.
I mean, they could just leave that field blank for this whole new area that we're going to make public, could they not?
Correct, that field just wouldn't show, or, yeah, I mean, and what you could do is on 921, say the information available for the Juvenile and Domestic Relations District Court shall not contain the name of the complainant.
So, second.
Okay. All in favor signify by saying aye. Aye. Opposed. Okay, so what we're going to do is create it's going to be statewide searchable, and it's going to include adult domestic without the complainant. Okay.
Wait a minute. I mean, I'm happy to say July 1st, but I'm sensitive to her.
Oh, we haven't made that yet.
I know.
That's
we should talk about that.
Okay. Can you do it by January 1st?
That would certainly be better, but a year would be even better.
Okay. All right. So we'll Delegate Ransom, what's your preference?
We do have a fiscal impact with this, so we'll have percentage appropriations. I would defer her. I'm not doing the work. I'm not an IT person. I would hope that we know that this is coming. They could at least begin the planning stages and get a timeline moving on this.
Mr. Chairman, I make a motion about 1 January.
Okay. All right, motion is made to make January 1st. That'd be 2018. All in favor, signify by saying aye. Aye. Okay. So if it gets upstairs, we're not foreclosing them making a change in either direction. If they give me $10 million, I'm sure you can do it tomorrow. I doubt that's the plan. Okay. Okay, so I think does it have a FIS already, or we just know that it's going to get one?
It's
That's fine. So when we reach that point, the motion, if you wish to make, would be to report refer Delegate Albo.
Delegate Ransom, I recall there was some language we had where it wasn't going to require the Supreme Court to digitize records that are currently not digitized. In my version here, I don't see that. You know what I'm talking about? Do you remember seeing some language that said nothing in this bill shall require the Supreme Court to digitize old records?
It's only the participating.
Yeah, she clarified very bad time.
Delegate Albo, because it's maintained in the online case information system, so a case from 1864 is not maintained in the online case information system.
Okay. All right, thanks.
Okay, where are we at? We operate by motion. Is there a motion on the bill? Okay. Motion made to report for the bill. All in favor signify by saying aye. Aye. Opposed. Delegate Ransom, thank you. Delegate Silva. And then Yost, and then we get down to member bills. Everybody, this was the bill about, case goes upstairs, guy doesn't show, and they could, of course, issue a capias and put him in a fugitive file, or they could try him in his absence and give him a fine, but they want to find him guilty. And what are our parameters for this? It would also apply to anybody who just goes on the, just never shows up for a circuit court. Counsel, you found a case that would at least require us to do things differently if we want to do this, I think was your conclusion. Go ahead.
Mr. Chairman, concerns about whether or not people can waive their trial rights by failing to appear. I did find a case that, and I still have the concern of, because this is not an actual trial, of whether or not we can just affirm a judgment since the case is in the circuit court. However, that case applies to the waiver of jury when somebody fails to appear, and if we were to do this, we need to have something in the bill that requires the notice of appeal to inform people of this fact that if they fail to appear, the judgment will be affirmed, and probably even include the reopening of the case language as well. I think even reading further into the case law, we would have to require the judges of the General District Court or the clerks of the General District Court to warn people verbally about that issue as well.
I don't want verbal warning. So what I'm reading is this case you provided, Jose Luis Cruz, 1997, Cruz spelled like Ted Cruz, C-R-U-Z. And what they did is you would appear in court and then sign a form that said, I understand that I must appear in circuit court. I understand if I fail to appear, I may be tried in my absence and may be indicted for the felony offense of failure to appear. And then when the person didn't appear, they went ahead and tried him anyway. Is that the...
Right, those are the facts of the case.
Okay. Well, in this case, right, well in this case though, they want to, they don't want to do the, they don't want to try, they just want to have the appeal, the perfection of the appeal be withdrawn. It's otherwise the same idea, is that?
I think that's Mr. Chairman, that's the only law that we have out there, because we don't have anywhere else where we, other than civil, we don't have any criminal cases where we just don't try people if they're in the court.
And remind me again why they didn't just try him in his absence.
I can't speak to why they didn't, but the problem is that even if you do try them in their absence, you can't sentence them in their absence. And so as far as any kind of electronic reporting or anything else, it shows that the case is pending. And so, you know, from the eyes of anybody else, the case hadn't happened and no guilty verdict had been rendered.
I was thinking through some other options. I know back home we would on occasion try the case to get the conviction, keep the capias live. Because after a year or two, the case isn't fixable anyway, the cops left or something, and you would then, if they were caught him, they'd punish him with capias. You had the conviction in place.
Mr. Chairman, I guess in looking at what counsel provided, and I wasn't aware of the other one, but in the Hunter versus Commonwealth, I think it all really comes down to that you need to have some kind of express acknowledged notice of waiver of any right. So whether that's a right to appeal, whether that's a right to a trial, all of that really needs to come down to some kind of affirmative right. I know when I ran the language in front of you, the Commonwealth Attorneys Association thought that it looked really good, it was very clean. They also very specifically said that if you go this way, you do need to create a form or update forms in order to make sure.
Is OES here? Yeah, I don't know if we need your input, but you're listening, because what we're suggesting would be by July 1st, when this goes into place, the new appeals form that's filled out by the tens of thousands needs to have some language that says, hey dummy, if you don't appear on the day that we've now scribbled in, this will constitute. Okay.
Mr. Chairman, Eileen Smith, we change anywhere from 50 to 70 forms effective July 1 is what we do. The only question I have, I would rely on the statute and say I need to change the form based upon the bill. I'm not aware of this case, and so if I'm not aware of the language that you all are contemplating, then it's not going to end up on the form just because I don't know it.
That's right. It would be. I mean, we're not there yet. Is willful failure what we want? I know you and I talked about this, David, but I as counsel or staff. So there's all sorts of ways we could say this. I skip court because don't want to go.
Mr. Chairman,
I'm drunk, which was the case here. I'm not drunk, but somebody slipped me a roofie last night. I'm being held at gunpoint. Those are sort of the range of how much moral culpability I have in not showing up.
I think, Mr. Chairman, I think willful was used because that's what we use in 192128, which is the failure to appear statute. That covers failing to appear. And for any other case, willful, I think, gives the court the discretion to decide whether or not your excuse is good. I'm sure there's a court that may think that getting drunk the night before and being late for court wasn't willful because you didn't need to sleep in. But I think it gives them the discretion in that point. And I can see also courts that if the word willful is not in there, that any failure to appear would be considered this, and there would not be any reopening.
Okay. Back up. Is there any time you don't want to let them withdraw the appeal? You really can't. Did you rather try them in their absence?
Mike said going clear to the city of Lynchburg, and there may be a few times where we would rather they've done, but we can't stop them.
You can't stop them. So that's what I'm saying. So if they walked in and said, I'm not.
We cannot stop them. That is exactly right. So I mean, I have seen times where there have been
This is a pretty significant change in the appellate procedure. It's going to change how we all advise our clients that if you don't show up, they're just going to impose the penalty from below.
The chair's question concerning willful, if we didn't have willful in there, even if the person called up and said, hey, I'm not going to make it today, my car broke down, while whatever it is, the court would say, well, the word willful's not here. I have to make you're withdrawing your appeal, whereas the guy doesn't show up, there's no explanation whatsoever. The court basically comes to the conclusion that there was a willful failure to appear. But then you look to lines 33 through 37, and it says, well, but you still got, it was 60 days, you've had your appeal withdrawn because you didn't appear. You come in and say to the court, hey, I didn't come up because my car broke down, and oh, by the way, the battery was dead on my cell phone, so I didn't call in either. And the court finds that to be the truth, then the court can basically say, fine, your appeal is now perfected, and we will now go forward in the circuit court with your appeal. It doesn't go back to the district court, it stays in the circuit.
We had a discussion of where the paper file resides. When an appeal is withdrawn, do they send it back to the district court for?
Once 10 days, Mr. Chairman, once 10 days have run from the date that the appeal is filed, all the papers are sent over to the circuit court and then stay in the circuit court. So that file will remain in the circuit court.
All right. Delegate Albo, and then anybody else, and then let's.
Okay, so I thought of a problem. Tell me if I'm wrong. So I represent a client for a DUI, say a DUI second, and I'm talking to the prosecutor, and the prosecutor says, I can't get blood alcohol, the breathalyzer operator here, I'll tell you what, I'll give you a DUI first, but I'm only giving it to you because of the fact that I got a problem. So your client accepts the deal. Then 10 days later, he appeals it without you knowing it. And then he decides never to show up to court. And now the prosecutor will be in a situation. Does this bill mean that the worst punishment that person can get now is affirming a DUI first?
Mr. Chairman, the answer is yes, because we couldn't stop him from doing that anyway. If he showed up in circuit court the day of his trial and said, I withdraw my appeal, we're like, well, I don't like it. I don't like the fact he went behind my back on a plea agreement, but I can't stop you from doing it, even though we not done the DUI first. We're just stuck with it. And again, there are cases where, we've tried them in general district court. We thought that the punishment may be too low, but in spite of that, the defendant notes their appeal, and they get up to the higher court, and we'll be getting ready to argue for a higher penalty, but they withdraw their appeal. Again, we're stuck with that.
They have to withdraw their appeal prior to the hearing to be able to get.
Yes, Mr. Chairman, yes, the answer to that.
So you bring in everybody, your full board.
When I say prior to the hearing, I mean the case is called. How do you plead? I withdraw my appeal. Bada boom, bada bing. It's whatever happened in the district court.
Mr. Chairman.
That's not how it works. At least some jurisdictions say, sorry, you didn't withdraw your appeal yesterday, so now it's a brand new show. Because it says, for the prosecution, person withdrawing appeal shall give written notice of withdrawal to the court and counsel for prosecution prior to the hearing date of the appeal. In lines 15 and 16. In almost all cases where I work, the judge says, sure, I'll let you withdraw the appeal because they don't want to have to screw the trial, right?
Mr. Chairman, that's what I was about to mention, is that was my understanding of the statute, and I have seen some cases where if somebody is sort of jerking around the system of the prosecution, then the court may say, well, we're here for trial now, so you can plead guilty if you like, but I'm going to re-sentence.
And then conversely, for the guys who don't show up for term day, and then you said it without telling them, and you kind of know they're not going to show up, you have still to, this will clean that whole mess up. Somebody in a huff appeals, and then they're gone to the win. And then term day comes, and you said it, everybody knows they're not going to show up, you still have to spin all the witnesses, and you're prepared, and get ready for trial, even though nobody's ever heard of the person before or since. It's just gone. And that would be a not insignificant benefit to having a setup that says you've got to be there.
In addition,
like I said, as a jury trial, they did that once.
Pardon me, Mr. Chairman. It would also solve that problem insofar as that you would not then have given that defendant proper notice for whether or not you can send out a show cause or a habeas. So that would be an additional benefit as you were speaking about.
Okay, counsel, anything else? We've had this twice before, so let's move off the dime. What's the pleasure of the committee? A motion has been made to report. Is there a second? Second. All right, all in favor signify by saying aye. Aye. Opposed? No. Okay, noes, raise your hand. 1, 2, 3. Okay, 3 noes. Okay, the bill passes. You need to be there at full vote.
I will definitely be there.
Okay. Delegate Yost, you're up.
Thank you, Mr. Chairman, members of the subcommittee. This is House Bill 2284. This is a charitable gaming bill that seeks to fix a couple issues that have arisen over the last year. The bill provides that any person who fails or refuses to obey any subpoena issued by the State Department of Agricultural and Consumer Services is guilty of the Class 1. So, Mike. How about that? Do you want me to go start over again? Yeah, sure. This is a bill that was seeks to fix a couple of technical adjustments for the Virginia Department of Agriculture and Consumer Services under the charitable gaming laws. It provides that any person who fails or refuses to obey any subpoena issued by VDEX is guilty of a Class 1 misdemeanor. And there is somebody here to speak for the bill if necessary.
All right, sir, tell us your name and tell us your thoughts on this measure.
Mr. Chairman, Bud Oakey, representing the Virginia Charitable Gaming Council. The VCGC requested this bill to be put in this year to help strengthen the law based on a case that the department had where a recipient of a subpoena refused to comply. They went to the Supreme Court with this, the state Supreme Court, and the state Supreme Court said because there was no penalty, it had no recourse, and this bill simply adds a penalty so that there is weight behind the subpoena with the department.
All right, okay. All right, let's slow this down. Some of us are now realizing what a big deal this is. So, Delegate Albo, you're looking up what this is.
Yes.
What is this? It's been issued by the department in accordance with subdivision 4, Victim 2, 340.18.
Yeah, this is the powers and duties of the department. I'm assuming it's the Department of Charitable Gaming.
Department of Agriculture and Consumer Services Office of Charitable Gaming.
Okay, and subsect it gives all their powers, and they can supervise charitable gaming. They can charge people with violations of the gaming laws. They can compel the production of books and documents. In subsection 4, they may issue subpoenas for attendance of witnesses before it. Which then arises to the part that how come we're only putting penalties on number 4, because if we put only penalties in subsection 4, we're now saying there's no enforcement for all the other subsections.
Delegate Klein.
Question for the patron.
Why do you feel that it is necessary to have penalties that are higher than the penalties for failure to obey as in a criminal matter?
Mr. Chairman, we left that up to staff to decide at what level. We're open. We just know that based on the Supreme Court opinion that with no penalties, the department cannot force somebody to comply.
Okay, so
we'll leave that judgment up to you, gentlemen.
Contempt, which is normal for criminal matters, is acceptable.
I can? Awesome. Wow.
Can we repeal that authority? David Alva's contempt
Yeah,
authority
right.
is part of it. Okay. Mr. I guess I've got the gavel right now. And I feel like that's a better, more appropriate punishment. I don't mind giving them the ability to find the party in contempt for not following a subpoena, but Mr. Chair.
Okay, so in case you want to hear what my opinion is.
Always.
Oh, yeah. So when courts make decisions, they make decisions only on the facts before them, right? So they were brought this case, and this case only dealt with this section 18.2-340.18 subsection 4. And they made a determination that there is no penalties, and therefore subsection 4 is unenforceable. I worry that if we put this one specific punishment in for here, then are we then saying that every other administrative agency has no ability to enforce any of its orders or rules?
That's all.
I mean, whether it's ag or whether it's Department of Commerce or whomever.
Mr. Chairman, I can tell you that there are several boards that have this power as well. So this is not an unknown thing for the General Assembly to do. The Board of Social Services is a Class 1 misdemeanor. The Milk Commission is a Class 2 misdemeanor to punish for this. The ABC Board is Class 1. Their Board of Supervisors, they are Class 1. They can be a Class 1 misdemeanor. So it actually is different. So there is a, I think the General Assembly just has to give them the power to do that.
Can I ask counsel a question?
So,
does the Milk Commission have this phrase, refuses to obey any subpoena issued by the Milk Commission?
Mr. Chairman, if you give me 1 second, I'll pull the statute up. Of course not. Look. No. That's 3.2.
Any person?
Mr. Cotter's line.
Mr. Chairman, 3.2-3218, any person failing to comply with any subpoena issued by the Commission or pursuant to its authority is guilty of a Class 2 misdemeanor. And each day during which such violation shall continue is a separate offense.
Make it a Class 2 misdemeanor, just make it the same as everybody else.
But the same as everybody else is usually done. Right. Are you arguing about that?
Mr. Chairman, I was going to bring up the issue that it should say willfully fail or refuses to obey.
We're going to have to create a new subsection anyway, if we're going to make it a contempt penalty.
Mr. Chairman, also, with the contempt part, you have to refer it to a certain court, so there is some other language in the bill.
Sounds like it needs to go by at least temporarily, but probably longer for you guys to work with the patron and come up with the right wording. We've got in concept misdemeanor to contempt.
Hey, Mr. Almost Chair?
Yeah.
What I'm
Mr.
concerned
Hasman,
about
Chair.
getting so specific that we've now ruined it for everybody else. So, I would prefer that you, unless it just happens to be missing out of this section, in other words, unless the Department of Agriculture is the only department that doesn't have the power to bust people for not complying with subpoenas, then we would make it specific. But if that's not the case, then we are causing more problems than we're fixing.
Mic drop.
Mic drop. Out.
All right, Mr. Chairman.
Sure. I mean, this is a staff issue. I mean, can you guys figure this out? I mean, this is, Uber Chair is correct. I mean, it's weird that this isn't already covered. It'd be much easier to slot it into an existing box. Only if it is neither of those should we create a new freestanding section that then by definition means every other single part of the code that doesn't have that exact same language was purposefully left off for that reason. I mean, it's a massive problem if we mess this up. So
We will yield to your good judgments.
if Mr. Chair, if you would like to take it back for the day, that's perfectly fine. Is this something you can you do this in the next 10 or 15 minutes, or I can bring this? That's fine. All right, yeah, we'll go back to the day. All right. Thanks. Someone had asked about 1613 was on our docket, but neither the patron is here nor have there been any interest in it. Were we asked to move 1613? 1613 is listed on my docket in the first block. I don't see Delegate Marshall. So to the end of the docket. Okay. Yost, we have Collins, Gilbert, Herring, and Miller. That's it. Collins, just alphabetically.
We can take up the...
Does anybody have any, do any of those people have any witnesses here? I do. Okay. Can we try to use her? Sure. Delegate Herring.
Mr. Chair, if I could start with 2087, and because there's an amendment that I gave Mr. Carter, because this is a bill, by the way, though, you all will probably be reminded that what I filed last year. The issue that we're trying to address is that judges are not pinning down the reason for their departure from the guidelines as required by our law. We had judicial interviews in December. We asked questions, and some judges said, yeah, I sometimes forget. And that's a problem, and I'm just trying to figure out a way for defendants.
I'm sorry. Do you want us to work from this draft, or do you have?
No, let's do the amendment.
Go ahead. If you could let us report the amendments, we can listen.
Sure.
Mr. Chairman, on line 21, after the court shall, you're going to strike the remainder of line 21 all the way down through line 23, and you're going to insert provide a written explanation of the departure and shall file it with